On October 1st, 1946, the judges of the International Military Tribunal at Nuremberg read out their verdict on Grand Admiral Karl Dönitz, the man who had commanded Germany's submarine fleet and who had briefly been Hitler's successor as head of state in the final war's days. He was convicted war crimes, among the specific charges conducting unrestricted submarine warfare in violation of the 1936 London Naval Protocol, a treaty Germany had signed which required submarines to identify ships, warn civilians, and ensure their safety before sinking them. And then, in the very next paragraph of that same verdict, the tribunal wrote this. I'm going to quote it directly because you need to hear the exact words. In view of all the facts proved, and in particular of an order of the British Admiralty, announced on May 1940, according to which all vessels should be sunk on sight in the Skagerrak, and the answers to interrogatories interrogatories, 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 interrogatories by Admiral Chester Nimitz, stating unrestricted submarine warfare was carried out in the Pacific Ocean by the United States from the first day of the Pacific War. The sentence of Dönitz is not assessed on the ground of his breaches of the international law of submarine warfare. They convicted him, and then they said in the same document that they were not going to punish him for the thing they convicted him of, because the United States Navy had done the exact same thing in the same war, and the commander of the U.S. Pacific Fleet had just confirmed it in sworn written testimony. That's not a footnote. That is not a technicality buried in the appendices. That is the official judgment of the Nuremberg Tribunal, archived at Yale Law School, available to anyone who wants to look it up. Most people never have, and that's what this episode is about. My name is Dale, and this is a personal essay. That means I'm going to tell you what I think, not what the popular consensus says, not what the textbooks print, but what the evidence leads me to believe when I look at it straight. I've done the research. I'll show you the sources, but I'm not going to pretend this is a neutral analysis, because it isn't. I have a position, and the position is this. The United States of America conducted unrestricted submarine warfare against Japan beginning on December 7th, 1941, the same afternoon as Pearl Harbor. That campaign was illegal under the international treaties the United States had signed. It was morally and operationally identical to the German U-boat campaign the Allies prosecuted as a war crime, and the Nuremberg Tribunal knew it, which is why the verdict reads the way it does. I spent years in the United States Navy. I believe in that institution. I'm not saying any of this to tear down the men who served on those submarines. They were doing their jobs in a war their country needed them to win, and they won it. The Silent Service is one of the most effective and lethal fighting forces in the history of naval warfare. And the sailors who crewed those boats had more courage than I can fully account for. That is not what's in question here. What's in question is whether we held ourselves to the same legal and moral standard we applied to the enemy. And the answer, sitting right there in the Nuremberg verdict, is no. Here's a detail I want you to hold on to because it tells you something important about how this story unfolded. Dönitz's defense attorney, a German naval judge named Otto Kranzbühler, needed to prove that the US Navy had conducted the same kind of warfare his client was charged with. You know what he found? You know where he found the information? A library, a public library book about American submarine operations. The decisive evidence that would embarrass the entire Allied prosecution. The evidence that would force Nimitz himself to confirm under oath that the United States had run a identical campaign was sitting on a shelf available to anyone. He submitted writing interrogatories to Fleet Admiral Chester Nimitz, who was by then serving as Chief of Naval Operations. Nimitz answered them under oath. His answers confirmed exactly what Kranzbeuler suspected. The German practice of attacking merchant ships without warning. The American practice of attacking merchant ships without warning. The tribunal acknowledged they were, in the words of Döritz's own defense, indistinguishable. Dönitz was convicted anyway. He served 10 years in Spandau prison. He died in 1980 at age 89. Roughly 120 American admirals wrote letters saying his conviction was unjust. The world moved on. The verdict faded into history, and the U.S. submarine campaign in the Pacific became what it is today, a celebrated chapter of American military history. The Silent Service, the campaign that strangled an empire. 6% of Navy personnel responsible for over half of Japan's shipping losses. All of that is true. None of it answers the question the tribunal couldn't bring itself to answer out loud. If it was a war crime when they did it, who do we call it? What do we call it when we did it? Before I can make my argument, I owe you the strongest possible version of the position I'm arguing against. That's not a courtesy, it's a requirement. An essay that knocks down a straw man isn't worth your time to listen to, and it isn't worth my time to write. So, let me give you the conventional wisdom on this subject at its best. Fully loaded, honestly presented, the case as most serious advocates would make it. The story most Americans know goes something like this. On December 7th, 1941, the Empire of Japan launched a surprise attack on the United States Pacific Fleet at Pearl Harbor. More than 2,400 Americans were killed before breakfast. The attack was unprovoked by any act of war. The United States, responding to aggression it did not initiate, found itself suddenly fighting an island nation that depended entirely on maritime supply lines to sustain its war machine and feed its civilian population. The submarine force, the Silent Service, was the best tool suited to cut those lines. It did so with extraordinary effectiveness. 6% of Navy personnel, over half of Japan's merchant shipping losses. The single most decisive factor, by most assessments, in the economic collapse of the Japanese Empire. 52 submarines lost, more than 3,500 submariners killed in action, the highest loss rate of any branch of the U.S. Armed Forces in the Pacific. These men were not criminals. They were warriors who had won their war at enormous personal cost. And their campaign is rightly remembered as one of the great strategic achievements in the history of naval warfare. That's the story. And let me be direct. Most of that story is true. The facts I just listed are accurate. The men who crewed those submarines were brave beyond easy description. I'm not here to take any of that away from them, and I want that on record before I go any further. But The conventional wisdom doesn't stop at celebrating the campaign. It goes one step further, and this is where I think it starts to break down. The step further is this: the US campaign and the German U boat campaign are treated as categorically different things. Not just different in context, but different in kind, different in moral category. The U boat campaign gets filed under war crime. The Silent Service campaign gets filed under decisive victory. And the question of whether those two filing systems can coexist, whether the same act of war can be a crime when one nation does it and a celebrated achievement when another does, that question simply does not get asked in most of the history books. The conventional wisdom has reasons for this separation, real reasons, not invented ones, and I want to lay them out fairly. The first reason is provocation. Japan attacked the United States. Germany did not attack Japan's shipping lines without cause, but neither was Germany responding to a surprise attack on its homeland. But neither was Germany responding to a surprise attack on its homeland that killed thousands of sailors on a Sunday morning. The emotional and moral logic of response to aggression is powerful, and it does real work in how Americans understand the Pacific War. There is something qualitatively different. The argument goes about a nation turning its submarines against the supply lines of the country that just bombed its fleet while sailors were still asleep in their racks. The second reason is the nature of the target. Japan's merchant marine, by the time the war began, was deeply integrated into the military supply structure. Liners had been converted to troop transports. Tankers were feeding the fleet. Cargo ships were moving war materials, oil, iron ore, rubber, ammunition, to forward bases across the Pacific. The argument is that this militarization of Japan's commercial fleet made it a legitimate military target in a way the British and neutral Atlantic shipping, which Germany attacked indiscriminately from the earliest days of the war, was not. You can debate the boundaries of that argument, but the argument itself is not frivolous. The third reason is the Laconia order, and I'll deal with this one more fully later in the episode because it's the sharpest point in the conventional defense. In September 1942, following a specific incident I'll describe in detail, German Grand Admiral Karl Dönitz issued an order explicitly forbidding U-boat crews from rescuing survivors of ships they had just sunk. The order stated rescue efforts contradict the most primitive demands of warfare. No equivalent written order exists in the American Pacific submarine record. That distinction matters to the legal scholars, and I'm not going to pretend it doesn't. Now, those three arguments are serious. They carry real legal weight. The definitive popular history of the American campaign, Clay Blair's Silent Victory, published in 1975, acknowledges up front that prior to World War II, unrestricted submarine warfare was considered, in Blair's framing, one of the most heinous forms of warfare, and that the United States reversed its position on the practice in under 24 hours after Pearl Harbor. Blair doesn't editorialize on that reversal. He lays it out and moves on. One reader I came across in researching this episode put it perfectly. Quote, "The author does not editorialize on this decision, but there is much to think about here for those so inclined." Most people were not so inclined, and I think I understand why. The conventional wisdom on this subject didn't become dominant through dishonesty. It became dominant because the war was real. The threat was real. The men who fought it were real. and the story of their sacrifice is genuinely worth telling and honoring. The campaign was also deliberately kept out of the press during the war itself. The Navy suppressed coverage of submarine operations for operational security, which meant by the time the war ended, the public had been conditioned to understand the silent service in broad, heroic strokes rather than operational specifics. A campaign the country never fully examined during the war was never fully examined after it either. I understand all of that. And I'm still going to argue that the conventional wisdom lands in the wrong place. The conventional wisdom is not wrong about the bravery of those men. It is not wrong that Japan attacked first. It is not wrong that the campaigns look different on the surface. What it gets wrong is the conclusion it draws from those real differences, that they add up to a different moral and legal category. I don't think they do. And the reason I don't think so isn't my opinion. It's the Nuremberg verdict. The judges who prosecuted Dönitz for war crimes looked at the same differences and still couldn't bring themselves to sentence him for submarine warfare. That's not nothing. That's the record speaking. So, let me tell you where the conventional wisdom starts to come apart. Not at the edges, not in the footnotes, right at the foundation. The first crack is a timing problem. The conventional defense of the American submarine campaign rests heavily on the nature of Japan's merchant marine. The argument that it was so militarized, so integrated into the war machine, that targeting it was a legitimate military act rather than an indiscriminate attack on civilian shipping. That argument has some real merit, as I said earlier. But here's what the argument requires you to believe: that the United States Navy, in the hours following Pearl Harbor, made a considered, legal, and tactical assessment of Japan's merchant fleet, determined that its military integration met the threshold for unrestricted targeting, and issued its order accordingly. That is not what happened. The unrestricted warfare order went out on the afternoon of December 7th, 1941. The bombs stopped falling at Pearl Harbor around 0945 in the morning local time. Admiral Harold Stark issued his order from Washington at 1752 in the evening Eastern Time. That's fewer than 8 hours. And Admiral Thomas Hart of the Asiatic Fleet, operating out of Manila, issued his own equivalent order even earlier that day, on his personal authority, without waiting for any direction from Washington whatsoever. Researcher Joel Holwit, in his archival study of the decision, documents that the order targeted, and I want you to hear this precise language, quote, all Japanese shipping, from fishing trawlers to freighters to tankers. Not military transports, not naval auxiliaries, not vessels confirmed to be carrying war cargo. All Japanese shipping, every category, no exceptions. The militarized merchant marine justification came later, applied retroactively to a decision that preceded any analysis of what Japan's merchant fleet was actually doing. That's crack number one. The legal justification for the campaign was invented after the order was already given. Crack number two is the question of who actually made this decision. The United States in 1941 was a constitutional democracy. The power to declare war rests with Congress. The conduct of war is the president's domain as commander-in-chief. The decision to abandon a treaty commitment, the London Naval Agreement of 1930, which the U.S. had signed, was a decision of enormous legal consequence. Holwitz research shows that senior Navy war planners had essentially already decided in the year leading up to Pearl Harbor that the Navy would conduct unrestricted warfare against Japan once war came. While the official U.S. government position remained publicly and formally committed to freedom of the seas, there was no public debate, no congressional discussion, no presidential directive waiting in a drawer. Naval officers made a decision that overrode a signed treaty and directly caused the deaths of civilian merchant sailors. And the civilian government found out about it after the fact. Roosevelt was briefed on the submarine order at 14:28 in the afternoon. He approved it, but the Navy had already been moving before he signed off. I spent years in a uniform, and I understand the fog of that day. I understand why men in command positions made fast decisions under impossible pressure. But the fog of war is not a legal defense at Nuremberg. The Allied prosecutors didn't extend that courtesy to Karl Dönitz. I don't see why we should extend it to ourselves without at least acknowledging what happened. Crack number 3 involves something the standard histories almost never discuss. On April 1st, 1945, the American submarine USS Queenfish was on patrol in the Taiwan Strait. Her commanding officer, Commander Elliot Laughlin, detected a radar contact moving at speed through fog and identified it as a destroyer. He fired 4 torpedoes. All 4 hit. The ship sank in minutes. 2,003 people died. 1 man survived, the captain's personal steward, a man named Kantora Shimoda. He was pulled from the water and told Laughlin which ship he had just sunk. It was the Awa Maru, a Japanese vessel that had been sailing under a formal U.S. government guidance. A Japanese vessel that had been sailing under a formal U.S. government guarantee of safe passage. She had been carrying Red Cross relief supplies to American prisoners of war and was on her return voyage. Her route had been broadcast to American submarines. Her status had been communicated through official channels. She was clearly marked. She was where she was supposed to be. Laughlin was court-martialed. He continued his naval career. Now, I want to be fair about this specific incident. There is evidence that the Awa Maru was also carrying contraband cargo and high-value military personnel, which Japan loaded onto the ship in violation of the Safe Passage Agreement. Laughlin himself did not receive and had not read the critical dispatch about a protected status. The full picture of the Awa Maru incident is complicated. But here's what is not complicated. A U.S. submarine operating under the regime of unrestricted warfare sank a vessel sailing under Red Cross protection with 2,003 people aboard. And the commanding officer received a letter. The Laconia Order, Dönitz decision to stop rescue operations after a U.S. aircraft bombed his submarines while they were conducting a mercy rescue under Red Cross flags, is the centerpiece of the war crimes case against him. But the operational logic on both sides of that comparison was identical. In a regime of unrestricted warfare, protection status becomes unreliable. That's not a defense of Dönitz. That's a description of what unrestricted warfare does to everyone who wages it. And then there is the fourth crack, which might be the most uncomfortable of all. The United States went to war in 1917, in part because of Germany's unrestricted submarine warfare. President Woodrow Wilson said so explicitly. American newspapers called the U-boat campaign piracy. American public opinion called it barbarism. The sinking of the Lusitania, a passenger liner with civilians aboard, including over 100 Americans, was treated as a defining moral atrocity. Germany's willingness to wage war without distinction, the ship sinks without warning and leaves sailors to drown, was held up as evidence of a fundamental difference between the German character and the American one. 24 years later, 4 hours of deliberation, same order. I know some people are going to get uncomfortable, and I want to name that directly. Pointing out that the United States did this feels to a lot of people like an attack on the men who served. It isn't. Those men were given an order. They executed it under conditions of extreme danger. 52 submarines didn't come home. I'm not second guessing them. I'm second guessing the institutions that issued the order, prosecuted the enemy for the same order, and then spent 80 years declining to notice the contradiction. Let me build the case from the ground up, not from opinion, from the documents. The legal foundation of this whole debate is Article 22 of the London Naval Treaty, signed in 1930. Here's the actual text, the language that was in force by American signature on the afternoon of December 7th, 1941. In their action with regard to merchant ships, submarines must conform to the rules of international law to which surface vessels are subject. In particular, except in the case of persistent refusal to stop on being duly summoned, or of active resistance to visit or search. A warship, whether surface vessel or submarine, may not sink or render incapable of navigation a merchant vessel without having first placed passengers, crew, and ship's papers in a place of safety. For this purpose, the ship's boats are not regarded as a place of safety unless the safety of the passengers and crew is assured. That's the law, signed by the United States of America. Now, here's the part that the conventional history almost never discusses. When the main body of that treaty expired in 1936, Part 4, the submarine rules, was specifically carved out. The treaty stated in plain language that Part 4 remained in force without time limit. Without limit of time. Then, in November 1936, the United States signed a follow-on agreement called the Procès Verbal, essentially a reaffirmation protocol that committed all signatories to these exact rules. Over 35 nations signed it. The United States signed it. Germany signed it. Japan signed it. The obligation was not a relic from a previous era. It was current, active, binding American law on the afternoon of December 7th, 1941. And the order went out that afternoon, violated every line of it. Now, I want to read you something else. When Dönitz defense attorney Otto Krasbuehler submitted his written interrogatory to Fleet Admiral Chester Nimitz, he asked a series of very specific questions about American submarine practice. Nimitz answered under oath. Krasbuehler asked whether U.S. submarines were prohibited from carrying out rescue measures toward passengers and crews of ships they had sunk without warning. Nimitz answered, quote, "On general principles, the United States submarines did not rescue enemy survivors if undue additional hazard to the submarine resulted, or the submarine would thereby be prevented from accomplishing its further mission." Krasbuehler asked whether it was customary in operational zones for American submarines to attack merchant vessels without warning. Nimitz answered, quote, "Yes, with the exception of hospital ships and other vessels under safe conduct voyages for humanitarian purposes." Read that back. The Fleet Admiral of the United States Pacific Fleet, under oath, confirmed that American submarines attacked merchant vessels without warning and did not rescue survivors when doing so interfered with the mission. That is a sworn description of the identical conduct for which Dönitz was brought before a war crimes tribunal. Not similar conduct, not comparable conduct, the same conduct, in Nimitz's own words. And then Nimitz went further. After the trial, he is documented as having stated that the United States would probably wage unrestricted submarine warfare in future naval wars based on its success in the Pacific. He didn't call it a regrettable necessity forced on the Navy by circumstance. He called it a template. I served in the Navy. I understand the culture Nimitz came from. I understand the professional pride in a campaign that worked. That genuinely did strangle an empire and shorten a war. I'm not questioning the competence or the courage behind that assessment. But when the man who confirmed under oath that his Navy did what the Germans did turns around and says he'll do it again, that tells you something important about how the legal and moral question was being processed inside the institution. It wasn't being processed, it was being set aside. Now, consider where American law stood in 1917. 24 years earlier, when Germany resumed unrestricted submarine warfare in February of that year, President Woodrow Wilson addressed a joint session of Congress and cited the American diplomatic demand that Germany immediately abandon what he called its, quote, present methods of submarine warfare against passenger and freight carrying vessels. He told Congress that unless Germany stopped, the United States had no choice but to sever diplomatic relations. 6 weeks later, the U.S. declared war. The legal position couldn't have been clearer. Submarines attacking without warning were conducting indiscriminate, unlawful warfare. That was the official American position, stated by the president, confirmed by a declaration of war. On December 7, 1941, the United States reversed that position in 4 hours and issued the order. The Nuremberg Tribunal itself acknowledged, something that tends to get lost when people discuss the Dönitz case. The judges didn't cite Nimitz's testimony. They also cited a May 8, 1940 order from the British Admiralty directing that all vessels be sunk at night in the Skagerrak, the strait between Denmark and Norway. That order, too, violated the 1936 protocol. The tribunal was effectively acknowledging that every major Allied naval power had abandoned the legal framework they were prosecuting Dönitz under. Not one of them, all of them. The British legal scholar H.A. Smith, writing in the Naval Institute's own Proceedings Journal in 1955, 9 years after the verdict, put it in language that should have ended the debate. Quote, a war crime ceases to be punishable if the defense can prove that similar action was taken on the victorious side. He wasn't celebrating that conclusion. He was recording the tribunal's implicit logic and noting, with evident discomfort, what it meant. What it meant was this: the laws of submarine warfare were effectively nullified at Nuremberg. Not formally, not by any declared policy, but functionally in the sentence of a man convicted under those laws and then not punished for them. The tribunal acknowledged that the rules had been abandoned by everyone. The prosecution of Dönitz for submarine warfare was not justice. It was performance, the maintenance of a legal fiction that the Allied powers had conducted their campaigns lawfully when the trial's own record showed they hadn't. I want to be exact about what I am and am not claiming here. I'm not claiming that Dönitz was a good man. He was a committed Nazi who ran his submarine force in service of a genocidal regime. I am not claiming the U-boat campaign and the Pacific campaign were morally equivalent in every dimension. They weren't. What I am claiming is narrower and more specific. On the specific charge of unrestricted submarine warfare, attacking merchant vessels without warning, failing to rescue survivors. The United States Navy did what Germany did. The legal record says so. The fleet admiral said so under oath. The one thing I haven't fully addressed yet is the argument that keeps coming up whenever this subject is raised. Laconia Order. The argument that Dönitz explicitly ordered survivors left to drown, that American submarines never issued a comparable written order, and that this specific distinction is what separates a war crime from a lawful, if aggressive, campaign. I want to take that argument seriously because I think even that distinction, the strongest one the other side has, doesn't hold up the way people think it does. All right, here's where I stop building my case and do something harder. I'm going to try to beat myself. Not with a weak version of the other side, with the strongest version I can construct. Because if this argument doesn't hold up against its best objection, it doesn't hold up at all. And I'd rather find that out myself than have you find it for me. The strongest objection to everything I've argued so far begins with two Latin words. Tu quoque. It means you too. And in international criminal law, it is a formally rejected defense. The argument goes like this. Even if I can prove that the United States conducted the exact same campaign for which Karl Dönitz was prosecuted, even if Nimitz said so under oath and the Nuremberg tribunal acknowledged it in its own verdict, that doesn't establish that the American campaign was legal. It establishes that both campaigns were illegal. Two wrongs don't make a right. The fact that the prosecutors had dirty hands doesn't mean the defendant's hands were clean. A crime is a crime, regardless of whether the prosecuting authority committed to it. This is not a frivolous argument. The Nuremberg prosecutors actually anticipated it and built its prohibition into the tribunal's founding rules. They were, according to the historical record, explicitly, quote, determined not to let the defendants and their German lawyers turn the trial into one that would expose questionable war conduct by Allied forces. The U-2 defense was structurally excluded from the outset. And decades later, the International Criminal Tribunal for the former Yugoslavia ruled explicitly that the U-2 defense has no place in contemporary international humanitarian law. The international legal community has looked at this question and given a clear answer. You cannot excuse your conduct by pointing at someone else's. I respect that argument. It is internally consistent. And I want to add something else that makes the opposing case even stronger. The conduct of German submarines was not, in fact, limited to non-rescue. It went further. And the further it went, the harder my parallel becomes to sustain. War Order number 154, issued by Dönitz in 1939, stated in plain language, quote, do not rescue any men. Do not take them along, and do not take care of any boats of the ship. Weather conditions and proximity to land are of no consequence. That order preceded the Laconia incident by 3 years. It was not a response to being bombed while conducting a mercy rescue. It was a standing command from the beginning of the war. And then there was the Peleus incident. On the night of March 13th, 1944, the German submarine U-852, commanded by Captain Lieutenant Heinz Wilhelm Eck, torpedoed and sank the Greek steamship SS Peleus in the South Atlantic. Then, for approximately 5 hours through the early morning of March 14th, U-852 crisscrossed the debris field, machine gunning rafts, throwing grenades at floating wreckage, with survivors in the water the entire time. 41 people were aboard. 3 survived, adrift for over a month before rescue. 3 German officers were executed by firing squad in November 1945 for this action. There is no American equivalent. No U.S. submarine commander has ever been found to have actively hunted survivors in the water after a sinking. The difference between not rescuing people and machine gunning people in lifeboats is a real moral distinction, not a trivial one, and I'm not going to pretend it isn't. Legal scholar Nicole Heisey, working from the original Nuremberg documents at Cornell University, has argued that the tribunal's handling of U-2 in the Dornitz case was deliberately ambiguous, that the judges were navigating a genuine dilemma without wanting to commit to a clear precedent either way. That ambiguity has clouded the legacy ever since. Even Heisey's research, which is sympathetic to the complexity of the U-2 question, doesn't claim that the tribunal sentence nominally constituted an endorsement of American conduct. It was a legal accommodation. It was expedient. It was not a principled vindication of anything. And then there's the question of who started the war. Japan attacked the United States. Germany did not attack Britain's neutral trading partners because those partners threatened Germany's survival. It attacked them because an aggressive war of conquest required cutting off supply lines to enemies. The United States responded to a surprise attack on a Sunday morning that killed 2,400 Americans. There is a long tradition in the law of war that treating the aggressor's supply lines differently from the innocent neutral ship, and that the tradition has moral weight, even if the law as written in 1936 made no such distinction. These are real objections. The best lawyers and legal scholars in the international community have said, essentially, even if you prove the hypocrisy doesn't undo the crime. Even if the United States did what Germany did, both sides violated the law, and the additional conduct, War Order number 154, the Peleus killings, the documented pattern of active cruelty that went beyond non-rescue into murder, represents a genuine moral escalation that the American campaign never matched. I've sat with all of that. I've tried to find the place where it defeats my argument entirely, and I can't get there. Not because I think the U-2 point is wrong in principle. I don't. Not because I think the Peleus killings are morally equivalent to non-rescue. They aren't. But because I think the objection, even at its strongest, answers a slightly different question than the one I'm asking. The legal scholars are right that they did it too doesn't make something legal. I accept that. What they haven't reckoned with is the next sentence, the one that follows logically from it. If both sides violated the same law, and only one side was prosecuted for it, that's not international justice. That's victor's justice. And calling it by its right name isn't an attack on Nuremberg. That is a requirement for taking Nuremberg seriously. Let me take the counterargument apart in the order I presented it, because it deserves a specific answer rather than a general one. Start with U-2, the principle that two wrongs don't make a right. The legal scholars are correct that this is a formally rejected defense. The International Criminal Tribunal for the former Yugoslavia ruled it had no place in contemporary international humanitarian law. I accept that as a statement of legal doctrine. But here's what the legal doctrine doesn't tell you. Before the Nuremberg trial even began, Robert Jackson, the U.S. Chief Prosecutor, Associate Justice of the Supreme Court, the man who built the tribunal's legal framework, wrote privately to President Truman in October 1945, quote, "We have done or are doing some of the very things we are prosecuting the Germans for. The French are so violating the Geneva Convention in the treatment of prisoners of war that our command is taking back prisoners we sent them. We are prosecuting plunder that our allies are practicing it. We are prosecuting plunder and our allies are practicing it." That letter exists. It is in the historical record. Jackson wasn't writing that as a resignation letter. He was acknowledging the problem and then going to Nuremberg anyway, and building a prohibition on U2 into the tribunal's founding charter, specifically to prevent the problem from surfacing in open court. Justice William O. Douglas, his colleague on the Supreme Court, said publicly that the Allies were guilty of substituting power for principle at Nuremberg. These are not fringe critiques. These are not fringe critics. These are the people who built the trial. So the U2 principle, as applied at Nuremberg to the submarine warfare charge, was not a neutral rule invoked even-handedly. It was a rule designed by people who privately knew they were vulnerable to it, specifically to prevent it from being used against them. That is not the same as a principled rejection of logical fallacy. That is a legal structure engineered to reach a predetermined conclusion. And the tribunal acknowledged the problem in its own verdict by refusing to sentence Dönitz for submarine warfare. That means the rule against U2 was formally in place while the practical effect of the Nimitz testimony was identical to what U2 would have achieved. The legal scholars can have their principle. The principle is sound in the abstract. What I'm saying is that at Nuremberg in October 1946, on this specific charge, the principle was not applied to an equal playing field. It was applied by the guilty to the guilty in a structure designed to ensure only one set of guilty parties sat in the dock. Now, the Laconia order and the Peleus. This is the strongest part of the case. And I want to be exact about where I land on it. The Peleus killings were real. Commander Heinz Wilhelm Eck machine-gunned survivors in lifeboats, and 3 German officers were executed for it in 1945. That was a war crime by any honest definition, and I don't dispute it. But here is what the Nuremberg trial itself found out about the Laconia order. And I'm quoting the verdict directly. Quote, "The evidence does not establish with the certainty required that Dönitz deliberately ordered the killing of shipwrecked survivors. The orders were not an unambiguous command to murder. Ambiguous non-rescue orders, issued after a U.S. Army Air Force B-24 bombed 3 German submarines that were flying Red Cross flags, broadcasting an open rescue call in English, and pulling 1,500 survivors out of the Atlantic Ocean. The pilots were awarded medals. Neither the U.S. Pilot Command nor the AAF were ever held accountable." I was in the Navy. I know what it means to follow orders under combat conditions. I know the pressure commanders are under when every decision has life and death consequences for their crew. Dönitz issued a non-rescue order after watching a rescue operation get bombed. That does not make the order right, but it puts it in a causal chain. That begins with American conduct. And the Nuremberg prosecutors elected not to examine that chain publicly. Now, the aggressor argument. The strongest moral point the other side makes. Japan attacked first. There is real weight to that. I'm not dismissing it. But I need to point something out that I know from my own service. In the laws of armed conflict, they started it is not a recognized legal exception. The London Naval Treaty and the 1936 Protocol required cruiser rules regardless of who initiated hostilities. The law contained no clause exempting a nation from its treaty obligations because it was attacked without warning. That exception does not exist. It is a moral argument dressed in legal language, and every sailor who has studied the law of armed conflict knows the difference between the two. And beyond the legal point, the order was issued before anyone in Washington had conducted any assessment of whether Japan's merchant fleet was actually militarized. The justification was assembled after the fact. You cannot retroactively legalize an action by constructing the rationale once it's already done. There's one more thing I need to put in front of you because it completes the picture from the other direction, because it complicates the picture from the other direction. In September 1944, USS Pampanito and USS Sea Lion II were operating in the South China Sea when they attacked a Japanese convoy. They sank multiple ships without warning. Standard practice under unrestricted submarine warfare. Standard practice under unrestricted warfare doctrine. What they didn't know until afterward was that two of those ships, including the Rukoyo Maru, were carrying over 2,000 British and Australian prisoners of war. 1,559 Allied POWs died. The Pampanito returned and rescued 73 survivors, at great risk to her own crew. An act of genuine moral courage, and that I honor without reservation. But the attack itself, sinking ships carrying passengers without identification, without warning, is exactly the behavior the cruiser rules existed to prevent. The POWs died because American submarines did precisely what the law prohibited. The heroism of the rescue does not undo the legal character of the attack, and the law does not distinguish between a victim who is an enemy sailor and a victim who is an Allied prisoner. The protection existed for anyone aboard a merchant vessel. That is the rule the United States signed and violated. When I started researching this, I expected to find the contradiction at Nuremberg and work backward from there. What I didn't expect was to find Robert Jackson, the man who built the trial, writing privately to Truman before the trial started, that the Allies were doing some of the very things they were prosecuting. He knew. The people closest to the institution knew. They made a judgment call that the good Nuremberg accomplished was worth the compromise it required. Maybe they were right about that. Nuremberg did real, lasting good in the world. But there's a difference between making a necessary compromise and pretending the compromise didn't happen. 80 years later, we're still pretending. Here's what I believe. The United States of America conducted unrestricted submarine warfare against Japan beginning on December 7, 1941. That campaign violated the 1936 London Naval Protocol, which the United States had signed, which was binding American law, and which remained in force without limit of time. Naval officers issued the order in the same afternoon as Pearl Harbor, before any legal deliberation, without civilian authorization, targeting, in the explicit language of the order's own scholarly documentation, fishing trawlers, freighters, and tankers without distinction. The campaign killed thousands of civilian Japanese merchant sailors. The prosecuting attorney at Nuremberg privately acknowledged that the United States was doing some of the very things it was prosecuting Germany for. And the tribunal that convicted Karl Dönitz for unrestricted submarine warfare then wrote into its own verdict that his sentence would not be assessed on those grounds, because the fleet admiral of the United States Pacific Fleet had confirmed under oath that America had done the same thing from the first day of the war. That is my position. It is supported by primary sources. It is documented in public archives. It is a logical conclusion of the Nuremberg Tribunal's own written record, and it has not been honestly reckoned with in 80 years of American naval historiography. I want to spend a moment on why it still matters, because I can already hear the response. It's history. Why does it matter now? Here's why it matters now. The 1936 London Naval Protocol, the treaty the Nuremberg Tribunal cited, the treaty under which Dornitz was convicted and not sentenced. That treaty is still binding on the United States. There have been no new international agreements specifically governing submarine warfare since the interwar period. The Leiber Institute at West Point published scholarship as recently as 2025, confirming that the law of armed conflict regulating submarine operations remains underdeveloped. No new treaties. The World War II precedent is still the law. And here's the part that should stop you cold. The U.S. Navy's own Commander's Handbook, the operational legal document that governs how American submarines conduct warfare today, defines the legal basis of submarine interdiction of merchant shipping as the London Protocol of 1936. Quote, coupled with the customary practice of belligerence during the following World War II. Let's read that carefully. The customary practice of belligerence during World War II was unrestricted submarine warfare. That practice violated the London Protocol. The Navy's own doctrine is now explicitly built on the violation. The conduct that the Nuremberg Tribunal convicted Dornitz for and then declined to sentence him for has been absorbed into American naval doctrine as co-equal legal authority alongside the treaty it violated. Meanwhile, China never signed the 1930 London Treaty or the 1936 Protocol in any future conflict in the Pacific. The same theater where AUKUS submarines are being built right now, the same theater where the order was issued on December 7, 1941, the United States cannot invoke the treaty framework against China because China isn't a party to it. An international legal standard the United States helped compromise at Nuremberg by refusing to acknowledge its own conduct has been further eroded to the point where it may not govern the next Pacific conflict at all. This is not a distant historical concern. This is the legal environment in which American submarines will operate the next time they are called to fight. I want to close with something personal. I spent years in the United States Navy as a machinist mate, below decks, in the engineering spaces, doing the physical work that keeps a ship running. I wasn't a lawyer or a strategist. I was a sailor. And then I spent years after my service studying the institution I served in. Its history, its battles, the decisions made by the people who wore the same uniform I did. I put this podcast together because I believe naval history matters, because the sea is where the empires rise and fall, and because the decisions made in warships and in fleet headquarters echo for generations. The reason I made this episode is not to tear down the Navy I served in, or the men who crewed the submarines of the Pacific Campaign, or the legacy of the greatest naval war in human history. The reason I made this episode is the same reason I believe any institution worth honoring can survive honest scrutiny. A Navy that cannot look at its own record and say, here's where we fell short of the standard we claim to hold, is a Navy that will keep falling short of it. An institution that papers over its own contradictions doesn't resolve them. It passes them forward, laundered into doctrine, until they service in the middle of the next war. Joel Holwit, a United States Navy submarine officer who wrote his doctoral dissertation about this question, concluded that the December 7th order was illegal under international law. He didn't write that as an attack on the Navy he served in. He wrote it because he believed an institution you love deserves your honesty more than your silence. That's where I land. The campaign was strategically brilliant and tactically decisive. The men who fought it were brave beyond my ability to fully account for. And the legal and moral framework under which it was prosecuted was the same framework for which we held a German admiral in the dock, and then in the same document declined to punish him for it. Both of those things are true at the same time. They have always been true at the same time. I know some of you are going to push back on this one, and I genuinely want you to. That's what the Discord is for. If I got something wrong, show me where. If you have a source I missed, bring it. If you think the counter argument lands harder than I gave it credit for, make the case. This show exists because naval history deserves to be argued about by people who care about getting it right, not just getting comfortable. This one was just me, no Christoph this week, and I hope it holds up on its own legs. If it doesn't, that's on me. You can reach me at US Navy History Podcast at gmail.com. I'm on X at USN History Pod. Discord link will be in the show notes. Thank you for listening. As always, fair winds and following seas. Goodbye.